morning with an oral argument in the state of Ohio versus Nicholas Gedeon, case number 29153. State of Ohio has waived, so we will just be hearing from Attorney Ludwig on behalf of Mr. Gedeon. Obviously, you'll have 15 minutes. We've read the briefs and are ready to proceed if you are.
Thank you, Your Honors. Good morning, Your Honors. Mark Ludwig on behalf of Nick Gedeon. Nick was denied a speedy trial, was convicted without sufficient evidence of the drugs, denied a preliminary hearing transcript, indicted on an abuse of privilege, and convicted with unlawfully seized evidence. Other than that, everything went just fine. I know the court has said it's read the brief, but based on some recent experience, if there's anything, and how anyone can look at me and say this, if there's anything that's not fully developed, or if there's something the court sees as outside of the scope of our assignments of error, if you've seen that in the briefs, could we talk about that now face to face rather than reading it later? That's always disappointing. The speedy trial issue, we've agreed on the standard of review, d'novo. And if this issue is found well taken by the court, we need go no farther as much as we'd like some of the other issues addressed. But it's an end-all issue. Again, we've got to approach this with strict construction against the state. And Justice Moyer reminded of that in the Brecksville case. And that's important not to forget. There's 107 days of jail credit given at sentencing. So I don't think there's any dispute. We spent more than 107 days in jail, more than the 90 of the 3-day counting. The counting here is, as usual, we've turned justice into day counting. But the day counting here is, does the IILC holder count as a parole violation or a probation violation equivalent, which in case tolls the 3 days, because you're not held in jail solely on.
Mr. Ludwig, as to that specific issue, because I know with your brief, you certainly argued it is not that type of holder, but let me ask you, if your client was given a signature bond on this case, the case before us, or a monetary bond that he could have made, and I know again at some point bond was modified based upon your arguments at the trial court, but if he had been given those bonds, would he have been released? Or was there something still holding him on that island?
There was something still holding him. The way we currently treat the IILC, we treat it as a holder. And again, I've tried to address that. Number one, I don't think it is a holder. Number two, it's certainly not an arrest warrant, because unlike probation violations, IILCs don't grant the right to arrest. And I've always argued it's more like a detainer, and in fact I tried to use those words on the record and it was typed up as retainer, but I've always said it's a detainer. But even if it's not, even if it is a PV, the more important issue here is, do we let trial judges interject that evidence? With all due respect, and much more than this court, as much as this court is, that trial court's very patient with me. But the part that is grossly unfair is the state replies saying, gee, there was a holder. Before I can even answer that, the judge rules, yes, that's right, time's run. I reply with a motion to reconsider and say, wait, there's no evidence of this in the record. Now I face my second prosecutor. That's the fundamental unfairness here. On my motion to reconsider, the trial court introduces evidence of this IIC holder without argument, without opportunity to be heard, finds that evidence that the trial court introduced to be the equivalent of a PV, and then again denies that. Neutrality is gone. If we're working with some kid prosecutor that doesn't know what they're doing, and we've got to be patient, that's one thing. The Summit County Prosecutor's Office is very experienced. They don't need a trial judge introducing evidence for them, and then based on that evidence, without any opportunity to be heard, the opportunity to be heard part's important. We could have had this argument about whether it is or isn't a PV violation contested. And again, I'm sorry my opponent waved, as much as I don't like getting beat up. All right? The arguments here are better when they're two-sided arguments. And that's what happened down below. Bingo, the judge introduces the PV, says it's the same, and denies the speedy trial motion.
So you're saying the judge was wrong in doing that because why?
It abandons neutrality. It does the prosecution's job for the prosecution. It cures the prosecution's error. It proceeds as if the prosecution had introduced that evidence, had made that argument, and I have no opportunity to be heard on that issue.
Well, another way of looking at it may be that the court has an obligation to see that justice is done, and that people are brought to trial in a speedy manner, and that the state receives its fair share, and the people receive their fair share as well. So, you know, trial courts are blamed all the time whenever defendants are not brought to trial in a speedy manner, and their rights are violated and the case is dismissed.
Well, here's where we'll differ, Your Honor. I believe that the state of Ohio has no right to a speedy trial. Okay? I don't believe there's any justice afforded the state that it has a right to speedy trial. I believe it is the prosecution's burden to bring people to trial on time, and that it is the court's first and primary obligation to protect the individual's right, not do justice by introducing evidence that allows the court to deny a motion that was not properly opposed. There's where we differ.
So hypothetically, if the court knows, has a record in front of it, has a jail record, everything, and knows, for instance, that somebody has another charge, you know, that they're being held on, and so the triple time isn't invoked, and the prosecutor doesn't argue that, so the trial court should just say speedy trial?
Never. The trial court should look at defense counsel and say, what's your position on this? We should discuss this like we are now, face to face, on the record.
But if the counsel then doesn't say anything about, neither side says anything about the fact that the defendant is in jail on numerous charges unrelated to this case, then the trial court, speedy trial violated, even though the trial court knows that's not the case.
Well, if the trial court is prepared to testify, Your Honor, it's
Well,
what's
the trial court
in
is
the
going to make a
record.
decision. Well,
It's what's in the record. And justice is done. I mean, we're getting into a hypothetical that is a little different than these facts.
well, you're talking about the neutrality of the judge, that's what I'm asking about. And you want us to talk about things face to face, so that's what I'm.
Yeah, no, that's where I, and I think it is not the judge's primary obligation to bring people to speedy trial in the face of motions to dismiss that are opposed on a particular ground. Now, when we get beyond those facts, all right, we're starting into a case of let's distinguish, hopefully. We are now arguing to distinguish State versus Gedeon, where we found speedy trial was not allowed. We're into that area, all right? And again, I don't know that either in this case or on our Fourth Amendment issue, we are making broad, dangerous law that will be applied across the board. One of the things I heard was, well, gee, on IILC, every time there's a IAC holder, time will run regardless of the holder. No, if we're talking about things on the record, that's different.
So your complaint isn't necessarily that it wasn't in the record, it's that you didn't have an opportunity to argue. For instance, if the court just received a memo from the probation department, that's not going to be in the record, but your argument is you did not have an opportunity to argue that.
Your Honor, my argument is first, I made a motion to dismiss, this time it's greater than 90 days. The state opposed on the grounds saying there was a probation holder. The
And
trial court
if the
agreed
court-
with that. That was wrong.
But if the court had a memo, which is common from the probation department, indicating that they placed a holder on the defendant, that certainly doesn't
The
happen.
probation department can't place a holder on someone on an IILC.
If the court received such a memo, though, the court's not going to make that part of the record. Certainly, you're saying you should have the ability to argue. Just
Your Honor, are we off into the trial judge saying, but Mark, this is the way we've always done it? I'm sorry, Your Honor, you've done it wrong. Face up and say that and guide your trial courts appropriately. It's wrong, Your Honor, to have something off the record sent to the trial judge and it become the basis of a decision. Don't approve that conduct. This is a especially narrow case on that where you can say, look, even if you get something off the record, don't make decisions about it in the absence of notice and opportunity to be heard. It's both, Your Honor. They're not alone.
I think that's just what I asked you, so.
Oh, no, I heard you, perhaps wrongly, I heard you narrowing me down to only the fact that I didn't have a chance to be heard. No, the first go-round was enough, right there. Motion to dismiss, opposition on probation holder, no evidence of same in the record, motion granted. The Fourth Amendment suppression issue, if I can turn to it briefly. With all due respect, the trial court got that issue wrong both ways. It started the violation too late, and it ended the violation too early. By that I mean, the court found that the 48-hour rule isn't violated until its 48 hours has passed. I think the court's words were, it's ripening. This fruit was poisoned and ripe the minute those officers walked up to the car. In this case, in this particular case, Macedonia has admitted that we never get a probable cause hearing. We don't do it. We don't do it 12 hours, we don't do it 24 hours, we don't do it 48 hours. We don't do it. And that wrong begins as they walk up to the car, lock these boys in the back of the car, and go to begin to search. They know then we will not seek a probable cause determination within any amount of time. This case does not endanger police procedures across our counties. What it does remind them is, show me that your policy and practice is to obtain a warrant for detention forthwith. Now, you don't have to define forthwith in this case as 48, 24, or 12.
Because it wasn't done at all. correct?
It's not done at all, Your Honors. That has to stop. Now, if my excuse is, hey, I try to do it, okay? I take these guys in, I present them to a judge, I ask him to make a probable cause determination, and my defense is these darn municipal judges don't work. They don't do that. Or these municipal judges say to me, well, we don't do probable cause at an arraignment. That's for suppression issues. The beginning of this violation is, as Your Honor sees it, that is, they never do it. The end of the violation...
Hang on, Mr. Ludwig, I'm staying at the beginning of your violation. You keep talking about before a judge, I know...
Oh, any neutral and detached magistrate, Your Honor.
Arguably, though, I know in Akron, it can be sworn before.
Reasonably well-trained magistrate. reasonably well-trained clerk can
But
qualify.
here in Macedonia, it wasn't done with anyone.
It's not done with any.
Okay, thank you.
All right. And where does it end? Well, it ends, our trial judge said, it ends when we have a preliminary hearing. Wait a minute. A preliminary hearing is not equal to a probable cause determination. Preliminary hearing by rule can take place 10 days later. Even under any other rules, the probable cause determination has to take place much faster than that. And more importantly, they're different things. I could technically bring you a defendant at preliminary hearing and say, I beat the confession out of him, he said he did.
Counsel, thank you. You have used your time.
Thank you.
Court will take the matter under advisement, issue a decision in due course. The court will mail you a copy of the decision on the day it's released. You can also check the Ohio Supreme Court's website where the opinions are posted. Thank you again.